Hey, hello, and welcome to 528's second article. Today it's a bit of a heavier topic, so I wanted to avoid some of the intro stuff and get right to some background information to help this make sense because it is a bit of a important news story that deals with, like I said, a pretty heavy topic that people have strong opinions on. And the title is, Could Alabama's abortion ban help the movement to overturn Roe v. Wade? So what happened was Alabama, the state of Alabama and the state of Georgia made it illegal to have an abortion after more than 8 weeks of pregnancy. Now there are a few things that I feel like we need to talk about sort of ahead of time. And one of them, the first is Roe v. Wade. So Roe v. Wade is a landmark Supreme Court case, and what that means is that it was a law that was put into place, and it becomes sort of the baseline for how we view all other abortion cases. In this case, abortion cases. There are other landmark court cases. We looked at some about free speech, which are kind of the baseline for how we approach issues of free speech in the nation too. This one, of course, is about abortion. So the facts of the case are this. Roe, a Texas resident, sought to terminate her pregnancy by abortion. Texas law prohibited abortions except to save a pregnant woman's life. After granting certiorari, which essentially means that this took place at a lower court, maybe a state court or something. I guess I'm not sure exactly where it started, but certiorari means that a higher court will take a look at a case that happened in a lower court. So the national federal Supreme Court is going to take a look. The highest court in our nation decided to undertake this. The court heard arguments twice. The first time, Roe's attorney, Sarah Weddington, could not locate the constitutional hook of her argument for Justice Potter Stewart. Her opponent, Jay Floyd, misfired from the start. Weddington sharpened her constitutional argument in the second round. Her new opponent, Robert Flowers, came under strong questioning from Justices Potter Stewart and Thurgood Marshall. So the question was, does the Constitution embrace a woman's right to terminate her pregnancy by abortion? And here is your conclusion and how each of the justices voted. In the end, the court decided that a woman's right to an abortion fell within the right to privacy, protected by the 14th Amendment. The decision gave a woman total autonomy over her pregnancy during the first trimester and defined different levels of state of interest by the second and third trimesters. So the trimesters of the pregnancy. As a result, the laws of 46 states were affected by the court's ruling. Now, abortion is definitely a hot button issue, so I wanted to kind of talk about some pros and cons of legal abortion and what that means in terms of, the greater effect of that. Um, and we'll just kind of go one by one here. So the first pro legal abortion is this: a woman's right to choose abortion is a fundamental right recognized by the U.S. Supreme Court. January 22nd, 1973, in Roe v. Wade, in that decision. The cons against legal abortion: unborn babies are innocent human beings from the moment of conception. They have a fundamental right to life, which must be protected. Again, those of pro-legal abortion: a fetus is not a human being. Abortion is terminating a pregnancy, not a baby. Personhood at conception is not a proven biological fact. Personhood begins at birth. So sort of, when is that fetus a person, and what characteristics of that fetus make it a person? Con legal abortion: the Sixth Amendment, or the Sixth Commandment of the Bible's Old Testament is "Thou shalt not kill." Abortion involves killing a human being and defies a commandment from God. So religion ends up getting brought into the abortion argument as well. Pro-legal abortion, a third argument is this: fetuses are incapable of feeling pain when an abortion is performed, according to Stuart W.G. Derbyshire, PhD, senior lecturer at the University of Birmingham, England. And he said this: not only has the biological development not yet occurred to support the pain experience, but the environment after birth, so necessary to the development of the pain experience, is also yet to occur. The con legal abortion argument, third one, would be fetuses do feel pain according to during an abortion, according to this doctor here, whose name I'm not going to try to pronounce, who is a professor of pediatrics and anesthesiology and neurobiology at the University of Tennessee Health Science Center, who said, if the fetus is beyond 20 weeks of gestation, 20 weeks into the pregnancy, I would assume that there would be pain caused to the fetus, and I believe it would be severe and excruciating pain. So we've got a couple different arguments kind of for the pro and the con, and it ends up being an important platform for many political candidates because it drives their morals and the voters' morals as well, if they side with that candidate or not. So in addition to the pros and cons of abortion, I wanted to bring up sort of some live arguments. So I've got a pro argument and a con argument here. We'll start with the pro-life argument, and it's just a short clip of this man arguing for pro-life.
Some of these people were up here earlier talking, is we see the semblances of voluntary eugenics where we're talking about desirable traits, whether a child will be born poor. Well, it's the quality of life will be born if the baby has into a low-income society. Well, we're talking voluntary eugenics where we're deciding quality of life. And for me, the fear is that voluntary eugenics will slowly slip into state-demanded eugenics where if you don't reach a certain income, if you don't reach a certain IQ, it's just like the founder of Planned Parenthood says, they want to, from the beginning, Planned Parenthood has had a strict plan for forced eugenics. Margaret Sanger was a firm believer in birth licenses. She didn't even believe in the fundamental human right of motherhood. And now we're told that, oh, well, the organization has changed. It's new people. They don't think that anymore. Yet what is all of this that we're seeing now? They're saying that, oh, we're compassionate because we don't want the poor family to have the baby. Oh, we're now before it was hatred. We didn't want the poor people to have babies because we thought they weren't good for society. But now we're so loving. We don't want them to have the babies because it's not good for them. The baby won't be happy. The baby will have a poor quality of life. And we're told to say, well, you have the same thing that you've been saying for years, yet now you're loving about it. And it's very hard to accept that.
So there was a pro-life argument, and this guy here is going to make an argument for pro-choice.
The right to bodily autonomy is one of the most foundational principles that has guided this process. When a proposed restriction would violate this right, there's a very heavy burden to overcome before that violation can be justified. We tend to limit rights at the boundary of the individual. One person's right to swing their fist at some point ends at some point prior to contacting somebody else's nose. And I'd argue that even if we were to go so far as to declare the fetus a person, a huge irrational mistake in my opinion, that fetus's right to swing its umbilical cord ends somewhere prior to the wall of the uterus. When it comes to pregnancy, there are a lot of potential rights to be considered, and it may be the case that there's no compromise that will be satisfactory to all parties. The nature of the situation may be such that there are always going to be irreconcilable conflicts. How is it that one ignores the rights, desires, freedoms, health, and humanity of a living, breathing, thinking, feeling person in favor of another person, let alone in favor of a handful of cells or developing fetus that is neither viable or conscious? It's likely that you'll hear appeals to the value of life, things like it's human, it's alive, it's equal. But is it really? When we talk about the value of life, we're not talking about the value of a heartbeat. We're talking about the value of experiencing life, living life, awareness. Terri Schiavo was dead long before anybody pulled the plug, and a fetus, while it is as alive as a mass of cancer cells, under one definition, is not alive in the sense that it is not reasonably equivalent.
So there were two arguments and some pros and cons and a little bit of background. I think it's important that you have that in order to fully understand this article, and you should know that the views expressed in either of those videos uh, do not necessarily mean that I agree with one or the other. This is simply me presenting you with multiple sides of an argument. And so, given that, let's get started with the article here. Alabama Governor Kay Ivey signed the most restrictive abortion law in the country on May 15th, virtually eliminating the termination of pregnancy across the state, with few exceptions. 2 days later, Missouri lawmakers passed a bill that bans abortions after a fetal heartbeat is detected. Under the law, it will be a crime to have an abortion after approximately 8 weeks into pregnancy. Since then, even more states have passed legislation to limit or restrict abortions. The developments are part of a broader movement by abortion opponents and anti-abortion lawmakers across the country, emboldened by President Donald Trump and a conservative majority on the Supreme Court, to push legislation that could prompt the highest court to reconsider Roe v. Wade, a 46-year-old precedent that it protects the woman's right to terminate her pregnancy. "We have long opposed Roe v. Wade," said Clark Forsyth, senior counsel for Americans United for Life, an anti-abortion advocacy group and law firm. "It's an unjust and unconstitutional decision, and we hope that it will be overturned as quickly as possible. The question is by what means, what case, and what time frame." While the idea of access to abortion remains popular among the general public, the latest Gallup poll found that 79% of Americans believe abortion should be legal, and at least in some circumstances. It remains a major issue for conservative lawmakers and red-leaning states who have pushed forward on legislation that would make it significantly harder for women to get the procedure. But support skews heavily along party lines. An October 2018 Pew Research study found that 59% of Republicans believe abortion should be illegal in all or most cases, while 76% of Democrats believe it should be legal. Alabama's bill would criminalize abortions with punishment of up to 99 years in prison for doctors that perform the procedure and includes only limited health exceptions. But the bill does not exempt cases of rape or incest. In Georgia, Republican Governor Brian Kemp on May 7th signed a heartbeat bill that would ban abortion any time after the first 6 weeks of a woman's pregnancy. Often the earliest fetal heartbeat can be detected, though the term heartbeat is a matter of medical interpretation at that stage. Similar to heartbeat bills have already been passed or considered by other state governments throughout the U.S., including Kentucky, Ohio, and Tennessee. Abortion advocates point out that at 6 weeks, many women may not even realize that they are pregnant. "What we're seeing this year on abortion bans is unprecedented," said Elizabeth Nash, a senior state issues manager at the Guttmacher Institute, a research institution that advocates for abortion rights. "For 46 years, we've typically seen restrictions on abortion, things like waiting plans or limits on coverage. Those kinds of restrictions have been put on the back burner. Conservative legislators are now pushing near total or total abortion bans. Why are some states advancing controversial abortion laws now? While abortion remains legal at the federal level under Roe v. Wade, state legislatures have found ways to chip away at those protections. States have enacted requirements such as 72-hour waiting period and mandatory counseling, limited insurance coverage on the procedure, and required doctors to have admitting privileges to nearby hospitals. These restrictions have led to the closure of many clinics across the country, essentially eliminating access for women who cannot travel to different communities. 6 states currently only have one abortion provider, according to the Guttmacher Institute. Extremely restrictive bills, such as the one poised to become law in Alabama, are unabashedly an effort to force the courts to confront Roe, said Florida State University law professor Mary Ziegler, and they have gained more traction in recent years. Trump's appointments of Neil Gorsuch and Brett Kavanaugh to the High Court was seen by the abortion opponents as an opportunity to reverse Roe. "We're hoping that those new Supreme Court justices are pro-life, and we're going to test that theory and find out," Republican State Representative John Becker told the PBS NewsHour in an interview on Tuesday. Becker received national attention for introducing a state bill in April on abortion with the provision widely debunked as scientifically impossible impossible by medical experts. These bills are anticipating the gutting and overturning of Roe at the federal level, said Ashley Gray, state advocacy advisor at the Center for Reproductive Rights, a nonprofit that supports abortion rights. On May 4th, after passage of the Alabama bill, Republican State Representative Terry Collins said that the legislation is specifically about challenging Roe v. Wade and protecting the lives of the unborn because the unborn is a person who deserves love and protection.